Change is the new beginning. With this beautiful thought, welcome all, my dear friends. Let us continue our journey in the world of IPR by picking a section of the Patents Act 1970 as amended by Amendment Act 2005. Okay, so let us proceed. Now, again the old slide of the first lecture. Okay, friends, and this one I have given here just to refresh our memory. Okay, until now we have completed up to form number 5. So now it is the turn of form number 6. Okay, so let us take a look. Form number 6 has the title Claim or Request Regarding Any Change in Applicant for Patent. Okay, now you can correlate my thought that I said in the beginning of the slide, that change is the new beginning, just to symbolize this thing, because this one is the key point of our discussion. Okay, so form number 6 deals with any change in applicant for patent. Okay, and the claim or request regarding this change in the applicant for patent we will discuss. And for this, some correlated sections and rules are also available. So here the correlated section or the relevant section is section 20, that is power of controller to make orders regarding substitution of applicants, etc. Okay, and the rules are rule number 34, rule number 35 and rule number 36. So what is 34? 34 is rule number 34 is manner in which a claim under section 20 subsection 1 shall be made. Rule 35 is manner in which a request may be made under section 20 subsection 4, and rule number 36 is manner of application under section 20 subsection 5. Okay friends, after refreshing this slide, let us proceed to the particular section. Okay. Now, today's section we have taken is section number 20, and this comes from chapter 4, that is publication and examination of applications. Okay, the title of section 20 is powers of controller to make orders regarding substitution of applicants, etc. Okay, so I must tell you one thing, that please remember this point, substitution, because by remembering this keyword you can recall the whole section. Okay, so let us proceed to the next slide. Okay, the keywords for the subsections of section 20 are as below. Keyword for subsection 1 is assignment or agreement. Keyword for subsection 2 is consent. Keyword for subsection 3 is direction. Keyword for subsection 4 is deceased, and keyword for subsection 5 is opportunity. Okay, so just by remembering this 5 keywords you can very easily recall the specified subsections of the section 20. Okay, so let us proceed. Subsection 1 says, if the controller is satisfied on a claim made in the prescribed manner at any time before a patent has been granted, that by virtue of any assignment or agreement in writing made by the applicant or one of the applicants for the patent, or by operation of law, the claimant would, if the patent were then granted, be entitled thereto, or to the interest of the applicant therein, or to an undivided share of the patent or of that interest. The controller may, subject to the provisions of this section, direct that the application shall proceed in the name of the claimant or in the names of the claimants and the applicant or the other joint applicant or applicants accordingly as the case may require. Okay friends, very clumsy, very confusing. Okay, but you can remember the keyword assignment or agreement. Also you can observe here those letters in red. Okay, before a patent has been granted. Okay, the controller directs, okay, proceed in the name of the claimant, etc., etc. Okay, so here the related rule is rule number 34, manner in which a claim under section 20 subsection 1 shall be made, and form 6, that is claim or request regarding any change in applicant for patent. Okay, so this, let me simplify this confusing and clumsy subsection. Okay, so just listen to me. A request is made in form 6 before the grant of a patent, either by bit 1 an assignment, or bit 2 agreement in writing by applicant or one of the applicants in a joint application, or bit 3 operation by operation of law. Okay, by using these three modes, a request is made in form 6 before the grant of a patent to change the name of an applicant or applicants. If the controller is satisfied, then he may allow the application to proceed in the name of the claimant or in the names of the claimants and the applicant or the other joint applicant or applicants as per the requirement. This is the simple meaning. Fine. So, we can say subsection 1 is completed. We can proceed. Subsection 2 says, no such direction as aforesaid shall be given by virtue of any assignment or agreement made by one of two or more joint applicants for a patent, except with the consent of the other joint applicant or applicants. Okay friends, the simple meaning of this subsection is, we can say, for making a request under form 6, the consent of other joint applicant is compulsory or mandatory. Okay, that's all. Subsection 3 says, no such direction as aforesaid shall be given by virtue of any assignment or agreement for the assignment of the benefit of an invention unless, Clause A, the invention is identified therein by reference to the number of the application for the patent, or Clause B, there is produced to the controller an acknowledgement by the person by whom the assignment or agreement was made that the assignment or agreement relates to the invention in respect of which that application is made, or Clause C, the rights of the claimant in respect of the invention have been finally established by the decision of a court, or Clause D, the controller gives directions for enabling the application to proceed or for regulating the manner in which it should be proceeded with under subsection 5. Okay friends, so here we know the keyword of the whole subsection 3 is direction, and here are some secondary keywords as well identified by reference, produced, acknowledgement, rights, finally established, enabling the application, etc., etc. So let us proceed through this subsection clause by clause. Okay, so the clause A says the invention is identified therein by reference to the number of the application for the patent. Okay, so we will read along with this statement. Fine. No such direction as aforesaid shall be given by virtue of any assignment or agreement for this assignment of the benefit of an invention unless the invention is identified therein by reference to the number of the application for the patent. Okay, so you can also read clause B along with this statement, and you can read clause C likewise, and clause D also likewise. I'm just reading clause D. You can read each and every clause along with this statement. Okay. No such direction as aforesaid shall be given by virtue of any assignment or agreement for the assignment of the benefit of an invention unless the controller gives directions for enabling the application to proceed or for regulating the manner in which it should be proceeded with under subsection 5. Okay. So, we can simply summarize here that either of the, because here the operator is or, right? So we can say either of the above four clauses should be satisfied. Okay, either of the four clauses, that is A, B, C, D, should be satisfied for the assignment or agreement of the benefit of an invention by any assignment or agreement. Okay, because this statement is started with a, we can say that this statement is a negative statement. Okay, and it has some clauses which implies that either of the four clauses should be satisfied for the assignment of the benefit of an invention by any assignment or agreement. I think now it is clear. Okay, so let us proceed. Subsection 4 says, where one of two or more joint applicants for a patent dies at any time before the patent has been granted, the controller may, upon a request in that behalf made by the survivor or survivors, and with the consent of the legal representative of the deceased, direct that the application shall proceed in the name of the survivor or survivors alone. Fine. So, this is a particular situation. So here the important, I can say the main keyword is deceased, and the letters in red also are the secondary key points. Okay. So by keenly observing this, you can understand the summary of this subsection. So in simple words, I will say that if one of the joint applicants for a patent dies before grant of the patent, then a request is made by the survivor or the survivors with the consent of the legal representative of the dead applicant. Okay. The controller now directs that the application shall proceed in the name of the survivor or survivors. Fine. So now I think it is clear. Rule 35 is manner in which a request may be made under section 20 subsection 4, and form 6 is claim or request regarding any change in applicant for patent. Okay friends, because this is a particular situation where one of two or more joint applicants for a patent dies. This is the situation, and in this situation what will be done? Okay, that means how the request will be made, what the controller will tell, or the what the controller will direct. These things are mentioned in this particular subsection. Okay, I hope it is clear now. Now, subsection 5. Subsection 5 deals with another situation. Okay, what is the situation? Let us try to know this. Okay, subsection 5 says, if any dispute arises between joint applicants for a patent, whether or in what manner the application should be proceeded with, the controller may, upon application made to him in the prescribed manner by any of the parties, and after giving to all parties concerned an opportunity to be heard, give such directions as he thinks fit for enabling the application to proceed in the name of one or more of the parties alone, or for regulating the manner in which it should be proceeded with, or for both those purposes as the case may require. Okay friends, the keyword here is the opportunity, actually the opportunity to be heard. Okay, and the situation is the dispute, and here what the controller directs, that means what directions he gives for enabling the application. This one is the, so this particular subsection deals with a situation where any kind of dispute occurs. Okay, so in a very simple way, I can explain this. So just listen to me. If there is a dispute between the joint applicants of a patent on whether or in what manner the application should be proceeded with. That means this one is the, we can say, subject matter. Okay, I'm telling it again. I'm saying it again. If there is a dispute between the joint applicants of a patent on whether or in what manner the application should be proceeded with, this one is the matter. Okay, then the controller first gives all the aforesaid joint applicants an opportunity to be heard and then gives directions as he thinks fit. And what are the directions? The directions enable the application to proceed in the name of one or more parties alone or for regulating the manner in which it should be proceeded with or for both the purposes. Fine. So this is the simple meaning. So related rule is rule 36, manner of application under section 20 subsection 5, and form 6 is claim or request regarding any change in applicant for patent. Okay friends, so this way subsection 5 is also completed. Okay, so in this way all the subsections of section 20 are completed. Okay. The reference is the Patents Act 1970 as amended by Amendment Act 2005. Well friends, I feel you must have liked it. So please put down your queries, your compliments and comments in the comment box. And please like, share and subscribe the channel. Thank you so much for listening to me and thank you so much for watching my video. Stay safe, stay blessed. God bless you. Thank you all. Jai Hind.